this opportunity to say my sincere words for this very important event. Thank you very much.
Your Excellency, thank you very much for your opening remarks. It is indeed our honor to have you as our special guest today. Thank you very much, Your Excellency. The co-organizers of the online conference today also include the steering committee members of the AIA, which stands for Arab and International Arbitrators. So massive thanks to Dr. Hussam Talhuni, John McGowan, and Jamal Talhuni, who are the powerhouse of the AIA as some of the major events and developments in the field of international arbitration in the MENA region. So next, I would like to give the floor to Dr. Hussam Talhuni, a prominent legal and arbitration practitioner who acts as a legal advisor to the UAE Minister of Finance, and who also in the past served as the director of the Dubai International Arbitration Center. Thank you very much, Doctor, for joining us as the organizer for the event today. So the floor is yours.
Thank you, Diana. Well, good afternoon from Dubai and good evening to some others. Good morning to many, perhaps, other people with us in this webinar. Because this event is international, and I meant to say good morning and good evening and good afternoon. And that actually adds to the beauty of this technology right now, which we can use perhaps in the future dispute resolution, as now it is becoming an issue in every sense. And perhaps this is one of the topics that we could discuss today is how to get benefit or the benefit of the technology, particularly that it is now becoming part of our life to hold meetings via audio and video conference calls, perhaps with a more specific technology that would preserve the, let's say, our rights of confidentiality. Then arbitration can also get the best benefit out of that. We, as the AIA, which Diana has referred to it as the Arab and International Arbitration Group, this group was established in 2013, and we hold meetings twice a year almost. We held meetings in Dubai, in Abu Dhabi, in Qatar, in Kuwait, in Jordan, in various places in this region, in the Arab countries region with the GCC focus perhaps. And our members, as you see, are from various backgrounds with the focus of having the best quality arbitrators available in this region, coming together and have special relationship to meet, introduce to each other, perhaps to get the benefit of business development. And at the same time, during our meetings, we discuss various topics in arbitration, such topics that of particular interest to the arbitrators, not necessarily to be, about the general development of the law or general development of arbitration centers. Our focus is on the arbitrators themselves and how they could benefit from each other and from their relationship and special relationship together. Today's topic came to us, in fact, as one of the subjects we discuss from time to time, because in the past we discussed construction and then we discussed various other topics. But today this is a special topic relating to sports arbitration. It's an area not any arbitrator had the chance to explore because it relates to sports law in one area, and sometimes specialized type of sports like football or other areas where you have sports unions and special community that governs this area and develop it. We thought it worth to explore how arbitration or sport arbitration has developed in the not only in the GCC and Arab countries, but also to extend that to the whole entire Asia, to see if we have in Asian countries a sufficient ground to establish, let's say, a high level of dispute resolution in sports disputes. We noticed that the entire or the whole focus is in Europe, where they do have, of course, layers of generation after generation of development in this area, and they have developed, of course, sports law and practice, and we see the top well-known arbitration center is based in Europe, and the arbitrators specialized in this area also are based there. So we wanted to see how we can benefit from that experience and establish bridges and links together in order to develop this area in the Asian countries. So we did the simple research as much as possible, and we invited the best speakers who are going to also share with us today their experiences about how to develop sports arbitration or arbitration in the sports realm or area. So we have speakers from sports arbitration centers, and we have a speaker from who I personally invited from the UAE, who's one of the few specialized people in this region, Mr. Saleh, who will be a speaker today as well. So this is, Diana, this is in brief what I can introduce AIA and tell them why we selected this topic in this event. Thank you so much.
Thank you very much, Doctor, for your comments. As we've announced, our lineup of speakers today include the most prominent legal and arbitration practitioners in the world, specializing in the sports industry disputes. So next on the agenda, we have Nick DeMarco, Queen's Counsel, who is ranked as one of the leading sports law barristers and the foremost practitioner in the football disputes. Nick acts for football clubs, federations, players, and agents in commercial and regulatory disputes before FIFA, CAS, and various domestic fora. His presentation today resembles the topic of today's online conference, and that is the future of sports arbitration in Asia. Nick, the floor is yours.
Thank you very much. I've got some slides. I don't know if they can be...
Absolutely. I'm gonna...
I don't know where one can see those. But thank you very much for inviting me. It's a great pleasure to be virtually in Tashkent, and I hope one day to be physically there to meet you all. There's been a great interest over the past few years about sports law generally and sports arbitration in Asia. And it's been my view for a number of years that Asia as a whole, the region, is going to be the place where we see an exponential growth in sports law and therefore in sports arbitration over the next period. And so I think it's very good that you have an interest in this. Slide one is just, I'm not sure who's got, there you go. So that's just me. Just a brief introduction to me. I'm a barrister, which means basically doing the trial advocacy in the UK and advising. I now do only sports disputes, but sports disputes cover a variety of things, commercial and regulatory. And that will be a kind of a theme of my talk, because nearly all of the disputes I'm involved in are in arbitration. I would say 90% plus are in arbitration of one kind or another. It's very rare I'm in the normal courts, and that's because my practice is all in sports disputes. And those arbitrations are, as mentioned, they could be in CAS in Switzerland or FIFA, but there's a very large number in the UK, because the UK, probably outside of the US, has the most sophisticated and developed sports law market, primarily because of the English Premier League. And again, that is why my practice perhaps reflects the market is mostly in football, probably 85%, and then some in other sports. And so I mostly appear in arbitrations for the parties, but I do sit as an arbitrator, including for the International Athletics Federation and then a number of national domestic arbitrations. And I have a particular interest in arbitration in sport because it's so different, it's so special and peculiar to arbitration law generally. And that's really what I'd like to discuss in my talk. What's important about sports arbitration, what it is, and how it's different. And the first slide is something I'm sure you'll all be familiar with. When we consider arbitration generally, what we mean is a procedure to determine legal rights and obligations judicially with binding effect, enforceable in law, and reflecting in private proceedings the role of a court of law. I think that's a brief, adequate description of what arbitration is. And the features of it usually are confidentiality, it's in private, it's consensual based on contract, there must be a written agreement, it's judicial, they have to be fair hearing rights, legally qualified, neutral tribunal, etc. It's usually final and binding with no appeal. It's enforceable in the courts, and it's supported in law, including international agreements. So those are the common features of arbitration. But you'll see in my talk that in sports arbitration, many of those don't in fact apply or apply in a peculiar way. If we go to the next slide, why is it that we have arbitration in sport at all? Why not just deal with it in the domestic courts? I've listed some reasons there why most sports prefer to have arbitration than courts. I perhaps haven't put out the most important reason for international disputes. If you're dealing with something like the Olympic Games or the FIFA World Cup or any international tournament, and you obviously have common rules, if there was not an international forum for the determination of those rules or how those rules have been broken, you could have different results depending on different national law and different national courts. And it would then be impossible to have an equal playing field in a standard international competition. And that's why you have to have in Olympic sports and international sports a common standard arbitral process. The other more pragmatic reasons are arbitration is often more speedy and cost efficient. One of the things you might have to do is have an arbitration quickly before a particular sporting event, because you might be talking about banning an athlete or a player, for example. And so you can organize that more quickly in arbitration. Again, the decisions are normally final with no appeal, and that relates to the efficiency aspect. The arbitrators can be specialists in sport and ought to be, to understand it, again, to make it quicker and a better process. And also sport generally doesn't like its expression we have in English, I don't know how it translates. It doesn't like its dirty linen washed in public. It doesn't necessarily want all of its disputes in public. And so it likes that confidentiality. Many sports, like football, make it mandatory for all disputes to be in arbitration because they're concerned about national interference in the courts. On the next slide, you'll just see that this takes effect at the highest level within the FIFA statutes, for example. It is actually prohibited for a party to the FIFA rules to have any recourse to national courts. And the associations, the national associations, this is part 3 of Article 59, must insert, each national association must insert a clause in their regulations stipulating it's prohibited to take disputes to ordinary courts. and must impose sanctions against a party that doesn't respect that. So that's a very strong mandatory provision. Not only is disputes in FIFA subject to mandatory arbitration, but if a national association allows the disputes to be determined in national courts as opposed to within a national football arbitral system, then that entire national association can be suspended from FIFA, and that has happened to some national associations. On the next slide, you'll see I have identified, and this is, I mean, first of all, FIFA we've just looked at, but also all of the Olympic sports you're aware of, they're all subject to final jurisdiction at the Court of Arbitration for Sport in Lausanne, Switzerland. So disciplinary cases have a final appeal to the CAS, which is an arbitral centre. And then other sports, certainly in England, sorry, still on the last slide, other sports such as boxing, which is a big sport in England, has a compulsory mandatory arbitration system, as does cricket. Formula One does. It's got its own international court. It doesn't sign up to CAS. And then some sports don't. Rugby union doesn't, for example. Next slide. Is arbitration mandatory? For practitioners and for arbitrators, this has to be often the first question. Often the first question one has to look at is there an arbitration clause and is it mandatory? And I think someone needs to mute themselves.
بالنسبة إلى إجابة السؤال نسمع.
I'm afraid I've now been muted. I'm now unmuted. Thank you. So usually when we look at arbitration as commercial lawyers, you look at the contract to see whether there's an arbitration clause, and you construe the contract and that clause. The contract in sport, by and large, is the written rules of the National Association or the International Federation. And so that's where one normally finds the arbitration clause. Next slide, please. I've given an example. In English football, we have the FA, the Football Association. They have national rules, and they have this rule called FA Rule K in their handbook. And that makes clear, I don't need to read the whole thing, but any dispute or difference between any two or more participants, and by the way, a participant includes a club, a player, a referee, a director of a football club, an employee of a football club, anybody who's subject to the FA rules. So any dispute between two or more participants is subject to arbitration under the FA rules. So that clause means that, for example, I see many disputes between agents and clubs in England in relation to payments related to transfers. Those disputes must be determined under the rules of FA Rule K and not in the national courts, even though they are contractual commercial disputes. Next slide, please. So I want to move on to the differences between arbitration of private disputes and disciplinary disputes. Sports arbitration covers many things, and some people perhaps look at this more narrowly than others, but I look at the whole range of sports arbitration. If we turn to the next slide, it covers, in my view, two distinct things which often overlap. One is the normal private commercial contractual dispute contract lawyers will be familiar with. And the other is a completely different thing, a disciplinary dispute. So private disputes are things like that football agent claiming a commission against a club or a player where they've had a contract. Or a club against a club to do with a transfer fee, or a commercial sponsor against a club or a tournament organizer to do with a sponsorship agreement, or rights holder against a broadcaster to do with broadcasting. Any of those things may be subject to binding arbitration, either because of the contract between the parties, the individual commercial contract, or because of regulation. So the player against a club example in football, still on the last slide, please. The player against the club example in football. Sorry, can you turn back to page 9? Thank you. Has to be by arbitration, but it's a normal commercial private dispute. And then you have disciplinary disputes or regulatory disputes, things that cover, you'll be very familiar with doping or breach of laws of the games, misconduct on the field, cheating of some sort, match fixing, or big growth now in racism and discrimination or spectator misconduct, crowd invasions of football pitches or that kind of thing. But then there are also some quite sophisticated areas of arbitration we're often involved in, to do with things like breach of financial regulations that regulate what a football club in particular is allowed to spend. And so all of those are regulatory. In other words, you have a kind of prosecution. You have the sports governing body on the one side and the club or the player on the other side prosecuting, but they're subject to certain arbitral provisions. Next slide, please. And that means that many of these disciplinary disputes I've highlighted, the doping example, for example, will have wider implications in sport. Because if you think of doping cases as a very obvious example, you have standard sanctions, you have the WADA code, and you therefore have a body of case law and jurisprudence that develops that says how that code should be applied and what the sanction should be in particular cases. And that means you have to have the cases and the decisions published. And you have to look at, although there's a lot of debate about this, whether there is a system of precedence, binding authority in the case law. Now that, of course, is great tension with the normal approach in arbitration, that everything is in private, is confidential, and there's no precedent. But also other issues arise, such as consent. Is there really consent between an athlete and a sports governing body to arbitrate their dispute? Or is the athlete actually forced, in participating under the rules, to go by arbitration? And also public hearings. And that I'll come on to that in my next slide, please. The leading, most recent leading case on this was the Mutu and Pechstein case, two football player and a speed skater who were in their different sports banned for doping offences, and they were both involved in very long running years of litigation, right up to the CAS in Switzerland, where the final arbitration clause gave them a right to appeal their doping bans, and then challenges before the Swiss Federal Tribunal. And they claimed, amongst other things, that the arbitration clause was forced on them, and it denied them their human rights under Article 6 of the Convention in Europe to a fair hearing. And they based that argument on two things. First of all, they said the CAS wasn't independent. It was too biased towards the regulator. And secondly, they said they didn't have a public hearing. Their first challenge was dismissed, but if you go to the second slide, the next slide, sorry, you'll see that I've given reasons, and due to time, I won't go through that, but you'll see that the second limb of their challenge was successful, that they had a right to a public hearing, and that right had been violated. And that meant that from that case a couple of years ago, it is now law in Europe, and therefore affects CAS and FIFA, who are both based in Europe, that in certain cases where somebody can be banned from a sport and there are reputational outcomes, then they have a right to a public hearing. Next slide, please. And that has led to significant developments. You'll remember the Sun Yan case, the Chinese swimmer, was broadcast live, that CAS case. That's a result of this case. It's because of this case that he had a right to a public hearing. And there's also now been an amendment the year before now, to the FIFA disciplinary code, meaning also in football, in certain types of cases, you can have a public hearing. So again, very different to what we're used to in arbitration. The concept of not only the decision, but maybe even the hearing has to be in public, depending on the circumstances. So final slide, a quick summary. I've had to go through this quickly, so I don't want to go over my time, but I think the key points to take away from this are it's important in developing an arbitration center to have a specialist panel of lawyers and other, not just lawyers, but other specialists, such as scientists in doping cases, for instance, who have experience in sport. It's very important to have impartiality and independence from the regulator. If you have a sports governing body appointing the arbitrators or appointing more arbitrators than the participant does, then you have serious trouble in terms of its independence. You need clear rules in national rules in the national federations that make clear the extent and scope of the arbitration clause. There's a need for showing consent. There needs to be a flexible approach to confidentiality and to precedent. There needs to be, unlike normal arbitrations, the possibility of an appeal in disciplinary cases. And finally, you need to have rules that include speed, efficiency, and pragmatism for the sport to work. So that's the end of my presentation. Obviously, I'd be very happy to take any questions you may have.
Thank you very much, Nick, for a very informative and interesting presentation. As we mentioned, we have allocated the time for the Q&As with the audience at the very end of the event. Susan Ahern, another leading legal practitioner specializing in sports disputes, was kind enough to join us today as a speaker. Susan is a fellow of the Chartered Institute of Arbitrators. She's an arbitrator at the Court of Arbitration for Sport. She was appointed to sit at the 2020 Olympic Games in Tokyo as a member of the CAS anti-doping panel. She was the former head of the legal and legislative affairs for the World Rugby. Susan also regularly sits as a commercial arbitrator in an ad hoc and under institutional rules, including the ICC, and was recently appointed by the Irish government to the ICSID conciliator panel. Susan, the floor is yours. Thank you very much for joining us today.
Deanna, thank you very much, and thank you for that kind introduction, and good morning, good afternoon, and good evening to everybody on this webinar. It's an absolute pleasure to be with you today. And speaking about one of the topics and areas that I have a great affection for, and which has become very much my career in latter years. I think it's only fair to say that I have not come to sports arbitration necessarily in a linear legalistic fashion, but have gone through quite a different route, being an athlete first, then becoming involved in sports arbitration at national and European level, and ultimately converting that into becoming a sports lawyer and spending 15 years in that capacity with an international federation. So, you know, much of what I have to say is based upon that personal experience, and then combined with, I suppose, the more arbitration specific experience that I have sitting on a number of arbitration panels, including at the CAS. So speaking today, really, I think we all know that there's inevitability about sport and challenges. The very combative nature of sport and that environment does not lead to a silent acquiescence on the part of athletes. They are competitive, they want to win, and that is no less different where disputes emerge, be they contractual or be they disciplinary in nature, and both on field and off field. And recourse to arbitration is well established as a dispute resolution option. Sports certainly came to it, I think, primarily once they became members of the Olympic family. And as you will be aware, the Court of Arbitration for Sport was set up as a creature almost of the Olympic movement back in 1983-84. Now, that has evolved and changed, and Nick has spoken very well about the independence of the CAS, and that is now well established. But it does demonstrate that every arbitral body does have a starting point somewhere. And, you know, 1980-83 may sound like a long time ago, but it's not. It's quite modern. So in looking at what I think many of the people on this webinar are seeking to do, which is either to set up or become involved in sports arbitration in Asia, you know, you are just the next wave. And the benefit that you have over, I suppose, the European counterparts is that you have seen what has happened over that transition period. You have seen what can work, what doesn't work, and also the optionality that exists. Certainly, I believe that arbitration is a very effective medium to resolve sports disputes, and it does share a common heritage with commercial arbitration. But really, I think it is the younger sibling, and Nick has discussed many of the differences between the two, and I will go on and just elaborate a couple more. Anti-doping is certainly, I think, the unifying area where we can experience sports arbitration at its best, with the harmonized rules across the globe under the World Anti-Doping Code. It means that essentially there is one arbitral court, the CAS, which has a final say. Now, whether or not in your separate jurisdictions you have bodies, you will have bodies that deal with anti-doping cases domestically, whether they are premised on an arbitral model or not, is certainly one that you will be aware of. And whether or not that would fall within the confines of an independent arbitral body or is run by another institution, again, maybe the subject of deep consideration, as we know that WADA have, you know, certainly put greater emphasis in the 2021 WADA code with regard to the independence of decision making in anti-doping. So that is certainly something that will be a motivating factor and one to consider. Why do I think arbitration is of assistance to sport? Well, for me, the primary factor is that it ensures affordable access to justice. I mean, that's just absolutely essential and key, particularly for athletes, but also for sports associations and organizations who, you know, would not have necessarily the ability or the affordability to have recourse to the courts. And certainly the courts, particularly in Ireland and the UK, have very much said, we don't want to deal with sporting disputes where there are bodies who have greater expertise, provided that the necessary checks and balances are put in place. In addition, arbitration is very flexible in terms of being able to deal not just with the commercial contractual disputes, but also the regulatory aspects, which at times can be quite complex, you know, be it anti-corruption or anti-doping. And I think a refrain that you will hear, not just from me and from Nick, but anybody who is in this space, is that really the expertise, having arbitrators and having counsel who are expert in sports law and understand sport is essential, because it cuts through the melee, as it were, of knowledge and enables decisions to be made speedily and quickly, which again leads to justice, and that's of primary importance. Expedition, and I'll give you a couple of examples maybe later on, but expedition is absolutely essential in sport, which cannot wait for decisions, which if they're given too late will actually have no material impact. So it's interesting that, you know, Nick and I were covering some of the same ground, and he mentioned 5 areas where there's a tension between private disputes and discipline. And I was looking at that through the prism of how is sports arbitration different to commercial arbitration. So I entirely agree with the points that he made in relation to consent and confidentiality, public hearings, precedent, and independence. And to those, I'm just going to add maybe 3 more. And the first really is the bespoke list of arbitrators. Really, we do know that the specificity of sport, as it's referenced in the EU treaty, is important. It's unique, and it has so many components to it. You can't learn them from a book. So you need the hands-on experience. And that's why having arbitrators with bespoke knowledge of sport is essential. Again, feeding into the time and efficiency. And certainly that notion of the closed list was challenged for the Swiss Federal Tribunal, but was unsuccessful in a CAS context. And that was on the basis that having the closed list, and this is in the La Sutina case, on the basis that it ensured that the arbitrators were not just specialists in the sport, but that they would be able to issue fast and consistent decisions. And so that is key. But equally, I would caution that if a closed list is too closed or is too tight, it could lead to issues with regard to conflicts of interest and so on. So it's really important to spend a bit of time on looking at that. But certainly having that focus is hugely important and helpful. I've talked about expedited proceedings, and when we talk about expedition in the ordinary course, you're looking at a number of days rather than months. So if, for example, I look at an ordinary case in CAS, the appeal at the appeal level, you have 21 days, an appellant has 21 days within which to submit an appeal, and only a further 10 days in which to file the appeal brief and the evidence. And then the respondent has 20 days in which to submit their answer. And in the ordinary course, the tribunal is supposed to hand down a decision within 3 months. So that's pretty quick, not just for the arbitrators and those involved, but also for the counsel who are appearing in front of them. And so therefore being able to deal with these complex issues in this expedited timeframe where you really don't have opportunities to deal with discovery of documentation, multiple rounds of written documentation, where it may in fact be done on the papers in some cases. These are all traits that are symptomatic of sports arbitration. And let me just deal with the rugby union point, because I know Nick has mentioned that. And certainly in my experience as a disciplinary officer for World Rugby, in a Rugby World Cup context, you would have a super expedited procedure, which means that, for example, a red card case would be dealt with within 24 hours, including an oral decision with a written decision to follow within a further 24 hours. And there would be the ability to have an appeal before the next scheduled participation of that athlete in a match. And that really is again about protecting both the natural justice of the system and also ensuring that you're not dealing with things retrospectively, which can become super complicated in a sports arbitration context. And the final point that I would add is in relation to enforcement of awards, and in comparison to commercial awards, sport is on a whole different playing field. There is really no issue with enforcement of sports arbitral awards because the sports themselves just do it automatically, and they have the autonomy and they have the authority and scope to be able to enforce them within their jurisdictions. So unlike commercial arbitrations, it's quite a different issue. So really, sports arbitration is, as I've said, quite different, and it does help facilitate a consistency of decisions and public sanction and the importance of upholding the integrity of sport. I know many of you are certainly interested potentially in either becoming sports arbitrators or developing your practices in that area, or perhaps you've already started on that pathway. And there are just a couple of points that I wanted to touch upon that I think are maybe helpful. And first and foremost, it's that sport is concerned with the business of putting on matches, races, and games. That's what they're all about. And they do control discipline within the rules of their sport. And they try to do that within the pyramid structure, to do it internationally, regionally, nationally, and so on down to the club level. But many do not fully appreciate or have the expertise or the personnel to put in place the structures that they need to have a fully independent final decision. And so therefore, while at the first instance that may be available, many are looking to other bodies and independent bodies to be able to take on that burden that they may be unable to fulfill themselves. So for me, the starting point really is the recognition of the need for sports arbitration. So if in your jurisdictions there isn't an independent body that can do that, I would encourage you to start there, educating the sports on what is required, on what is best practice in other jurisdictions, and working towards establishing an independent body that can provide these facilities, either at first instance or on appeal or both. And having people with local knowledge of the local jurisdiction and of the sports will make a massive contribution. And it also means that the hearings can be held in the local language and speed and efficiency are dealt with. I also think it's important that athletes and sporting organizations and lawyers equip themselves with the theoretical knowledge and know-how about arbitration or about its possibilities, even if getting in depth is not a practical proposition. But certainly the peculiarities and the unique exigencies of sports disputes and also the international implications of those decisions warrant special attention. I suppose in preparing for today, I did have a look at some of the bodies that exist within the Asia region, and the Asian International Arbitration Center, for example, runs a certificate in sports arbitration. In fact, they had a sports month in September of last year. The Qatar Sports Arbitration Foundation has commenced operations in 2019, and they've already issued decisions. The UAE Sports Arbitration Center has really got up and going since June of last year, and they are looking to really build upon what has been there since 2012. And the Japan Sports Arbitration Agency has decisions on its website going back to 2003. So what that says to me is, you know, there is an understanding within Asia of the importance of sports arbitration. And lots of countries are seeing it not just as a means of dealing with disputes in sport, as we have discussed here today, but they're also seeing it as a means by which they can demonstrate, if they have such you know, an institution supporting sport in their country or their region. It's attractive for international sport, for bringing in international events and demonstrating a confidence in the legal system that is there to deal with sports and its unique specificities. I'm not going to get into the structure of a typical sports dispute. Nick has touched upon it, and most of you will be aware of it. What I will say though is that it is really, we have to also remember that sports are independent. And so one system cannot be foisted upon all sports. They have to be brought along with the process. And some sports, you know, the minority sports may feel that they have no option but to get involved and take things as they come. But the bigger sports will want to have a say and will potentially want to be able to pick and choose from an a la carte menu of options, as it were. If I look at, for example, rugby union predominantly deals with its own discipline. Now, the reason that it does that is because it has been very fortunate to have a great depth of lawyers and specialists around the world sitting on its own independent panels. Now, they're not arbitral panels, they are disciplinary panels. And for the most part, that works in that sport. but they, like every other sport, recognize CAS for anti-doping and also for all matters relating to Rugby Sevens Olympic participation. So that aspect of the sport is certainly falls within the CAS firmament. If you look at other sports, for example, International Tennis Federation, World Athletics, they now outsource their final appeals to Sports Resolutions UK International Panel. And I'm a member of that and have sat on a number of those cases. And so here you have a situation where a national body has done such a good job within its borders that it has now got the experience and the personnel within their lists to be able to provide a wider service to international federations and other parties. And I appreciate that my time is becoming quite limited, but I just want to give you an insight, for example, into the experience in Ireland, which does have, I would say, like a national CAS through Sports Dispute Solutions Ireland. And I am currently an arbitrator on its panel, but previously I sat on the board for 5 years. And I suppose this is in a way what I'm encouraging some of you to do, is to get involved in the structure itself, making sure that there is an entity which is suitably independent, which has the right rules, not just in arbitration, but I would also say in mediation, because med arbitration is going to become potentially a key aspect of sport in the future. And mediation can certainly be a very useful component of dealing with certain sports disputes, either as an accompaniment to arbitration, as a step before it, or potentially something that the parties can leave an arbitration and go into. But that's for a whole other day's discussion. So just to finalize the position in relation to SDSI, it was set up in 2007 by people who had sports experience, a number of whom were counsel to the CAS or involved in appearing in cases before the CAS and understood its importance. But for the early years, not much happened. And there was a question, so well, why was that? And of course, it was because the sports didn't really understand what it was about, and they didn't have the relevant provisions contained within their rules. So with the intercession of the funding body for sport in Ireland, funding was given so that the sports could review their constitutions and could include the arbitration clause. Most sports did that, or they included a version of it, and that comes back to the flexibility. And so now you have a situation where effectively all of the funded sports now have recourse within their rules in some form or another to SDSI. And for me, I sat on one case this year, which really brought home to me the importance of access to justice by an independent party. And it involved if one has a minority sport in one's country, well, this is a minority sport, where the individuals could not have gone to court to address the issues. And helpfully, their sport did have this arbitration provision. And for the first time ever, they were able to go to SDSI and have the case heard and dealt with independently. And I suppose, what that meant was that this internecine type warfare between members of the same club was now taken away from them, taken away from the sport, put into the hands of somebody who was an expert in dealing with these issues, and they got an independent decision which they were happy to abide by. And I think it's the bringing it home, it's the bringing it down to the base level of sport, the club sport within your respective countries. If you get it right there, then the international stuff will take care of itself. So on that note, I will finish, and I look forward to your questions and the discussion. Thank you.
Thank you, Susan. It was indeed illuminating for all of us to learn from your personal experience, and I'm sure that to many of our participants today, it was particularly interesting to get your tips for becoming a sports law practitioner and an arbitrator. You were kind enough to accept our invitation to speak. We are aware that you're in the middle of the hearing in a sports-related dispute, so we're beyond grateful for your time and your acceptance to join the event today. Last but not least, I would like to introduce our last speaker, Mr. Saleh Obeidi, who is the prominent legal and arbitration practitioner in the field of sports law from the Middle East. Mr. Saleh is a CAS arbitrator. His firm was the first firm in the Middle East to place dominant focus on the specialized area of sports law. Mr. Obeidi and his firm have represented clients in various sports areas, including football, horse racing, and motor racing. Mr. Saleh, the floor is yours.
Assalamu alaikum. Just to confirm, my voice is clear?
Yes, we can hear you.
Okay, thank you very much. Good evening here from Dubai. And hello, everyone. And thanks to AIA for this opportunity to speak about our beloved practice, which is the sports law. My earlier colleagues, Nick and Suzanne, actually have given quite a great overview to the sports arbitration. And I'm not here to repeat what they have said. I, of course, agree totally with them. Also, I understand, I've been with AIA for many times earlier, so I understand most of the maybe attendees are coming from the background of commercial arbitration. So in some aspects, commercial arbitration might be much more sophisticated than the sports arbitration, not always, but in various aspects. So I just would like to mention just a few points to make the sports arbitration accommodated by the commercial arbitrators or by the specialist in the commercial arbitration. I do both, so I can, and I've studied both, so I can understand why sports arbitration, for example, very clearly, most of their sports arbitrations goes to arbitration because arbitration, not because the parties have agreed in their contract to go to arbitration, but the regulations refer to arbitration. So this is one of the major difference between commercial arbitration and sports arbitration. And why? The question is why? Because many general practitioners or commercial arbitrations practitioner may disagree. And from a general perspective, yes, you could disagree, but in order to accept and to accommodate this approach from the sports law perspective, you need to go and understand why is this. So here I need to refer to a very main principle in sports law, which Nick has already referred to, which is the sports specificity. So based on sports specificity, this whole system of sports arbitration, which was originally driven by Court of Arbitration for Sports. By the way, I am a former CAS arbitrator. I recently left the closed list of arbitrators, and this is again one of the main things with sports arbitration. You will always have a closed list of arbitrators where parties have to select an arbitrator from that closed list. And the reason there are closed lists is to make sure that those arbitrators, other than they are legally qualified, but they have a proper and good understanding to the sports aspect, which is also the sports specificity. So also one major principle in sports law actually is the stakeholders. Sports arbitration is not related to external parties. It's related mainly to the stakeholders. We are speaking about sports federations, football clubs or clubs in general, to athletes, to players. We are not speaking about an external commercial company. Yes, it's true, a commercial company can still approach, for example, Court of Arbitration for Sports in Lausanne if they have agreed in their contract with their client to have CAS as an arbitral body to resolve their disputes. However, it's mainly designed, I would say, tailored design for the stakeholders. And again, one of the reasons my colleague Nick mentioned that arbitration and sports arbitration is fast. It's true. Yes, it could take a bit of time, but yes, it could be as fast as a decision has to be made within 24 hours. So nobody can understand this speaking from a commercial arbitration aspect. Not even the emergency arbitration or those new clauses that have been implemented in ICC and in various arbitration centers or arbitration institutes. In sports, whenever there is an international tournament, including, for example, the Olympic game, the FIFA World Cup, and many others, including actually the last Asian Cup, which was in Abu Dhabi 2019, CAS set and established an ad hoc division. That ad hoc division, why it's ad hoc as well? Because it's an exception from the rules of CAS. Why? Because that ad hoc division need to pass decision within 24 to 48 hours. Why? Because there's a competition going on, and this is the sport specificity. I hope now it's quite clear, understand by the audience, that in sports sometimes a decision has to be made that fast. So also mentioning enforcement, if you have a CAS award concerning football dispute, the enforcement, you will not approach or you will not enforce it based on New York Convention or maybe the national law. No, you have the international stakeholder or the International Sports Federation. For this example, FIFA will make the enforcement much quicker and easier. So these are just a few points I wanted to highlight. And just before, just as a last point, yes, I would like to refer to our region, the GCC and the Middle East and the broader region of the Asia. I mean, I was a former member of the AFC Legal Committee. We worked together with the SAC, which is the Saudi Sports Arbitration Center, which was the first sports center established in the Gulf countries. Recently, we have the Emirates Sports Arbitration Center. My message actually to, and my advice to all the stakeholders, including those sports institutes, they need to promote and to support all the candidates that, or the potential sports arbitrators. We need a proper, well-educated sports arbitrators to be able to add value way more than the standard arbitration or the national courts in relation to resolving sports dispute. We had a very good experience with the Saudi Sports Arbitration Center. When Saudi established the center almost now 3 or 4 years ago, they created a list of international arbitrators, just with a small number of arbitrators, but they have immediately designed specific courses to train candidates to become sports arbitrators. And it was a very successful experience. We have participated in teaching specifically CAS code and CAS jurisprudence. So I hope in our country, the UAE, they would do the same, and also for the rest of Asia. And again, thank you very much for this opportunity. I'm here and happy also to address any question or comment or feedback.
Thank you very much, Mr. Saleh, for your remarks and comments. Next on the agenda is the Q&A from the audience. Since everyone is muted now, for you to raise a question, you would need to first raise your hand so that I can unmute you. In the meantime, if any of our steering committee members of the AIA has any comments or suggestions or recommendations, we're more than welcome to hear from you.
Hi, Diana. Can you hear me? Hello, this is John McGowan. Diana, can you hear me?
Yes, we can hear you.
Yeah, well, thank you to the panel. Great presentations, really exciting to hear your perspectives. And of course, listening to the presentations, a lot of questions go through my mind, and I'll just put out a few of them, and maybe the panel can address them. I mean, Mr. Salah, for example, I was wondering what your take on how interface with the country of Qatar, where the UAE had been, having some issues. Those issues seem to be largely resolved now. What kind of impact did that have, over the course of 3 years? And where do you see the UAE's involvement in the FIFA World Cup, which is coming to Qatar? So that's a question that I was wondering about. And also from in terms of Nick and Susan, your experience, are you looking at Tokyo, for example? And the interface with agents, and in terms of the athletes, where does the lawyer fit in with the agent? Do the athletes all have their own lawyers? Do the agents have their own lawyers? That whole panoply of relationships, and also what percentage of your cases are on the record as opposed to hearings in the sports world? So these are some things that were running through my mind as you all were presenting. And of course, what about COVID? How has 2019 been? It's been a challenge for all of us. And, presumably there's going to be COVID challenges going forward. The UAE has been very good having sporting events and being very careful for the social distancing and the testing, and they're doing a great job, and they're having events. There's events this week in Abu Dhabi. There's a big fight. So so these are sort of the questions going through my mind. Sorry for the stream of consciousness, but if you all could address some of those issues, we'd appreciate it.
So I guess in my capacity as a moderator, I'm going to address the speakers that you've mentioned. Mr. Saleh, since you've been mentioned by John the First, so if you have any comments or feedback to the questions raised by John, we would appreciate it.
First of all, I'm very happy to see John doing well, alhamdulillah, and great to hear from him. Actually, not much to say about this, except that we are, of course, very happy to have this decision taken by the GCC Council, and welcome back Qatar, and of course, the flow and the great positive competition and the healthy competition between the GCC countries in hosting various international tournaments. This was something very great, and everyone is looking forward for the World Cup 2022, whether as fans or as practitioners. or and of course this specifically this we've been advising so many times stakeholders and right holders in hosting international tournaments. And this World Cup, specifically that one, the 2022, it's been a challenging one since the beginning, as everyone knows. So there was always, we always hear that UAE and other GCC countries may also participate. I have also, honestly, I have no comment here because I have no idea whether it will happen or not. But definitely the great infrastructure of the UAE will be always available, and it will be a great adding value to any actually international tournament around the UAE. So I will leave the rest of the question for my colleagues.
Thank you, Salah.
Sure. Susan, do you have any comments?
I do have a few. Just in relation, I wasn't sure what John wanted comment-wise in terms of the Tokyo experience, but I think for me the most important thing is it going ahead or not? So I think we'll wait and see what happens and take it from there. And I'm certainly not going to tempt fate in that regard, as I have a vested interest in it going ahead, as of course do all of the qualified and hoping to qualify athletes. I won't really talk about agents. I think that's something that Nick probably knows more about than I do. But in any of the football related cases that I have dealt with in CAS, most of them have been on the papers, and there have been no, in fact, some of the cases are actually taken by agents who are looking for fees. So you'll see a lot of cases by agents who are looking for their commissions against clubs who haven't paid them. So the agents are as much protagonists as the athletes or the sports bodies are. In terms of percentage cases on the record, in my experience, most anti-doping cases go on the record. The point in time is usually when the whole matter has been concluded. So that would ordinarily mean after the time for an appeal has expired. That kind of tends to be the general rule. In rugby, we certainly issued all of the on-field disciplinary decisions were issued, and the anti-doping. Not all misconduct cases were, but where you're dealing with a high-profile matter, then you can be pretty sure that it's going to be published. I have to say, I don't think any of my cases that I've dealt with in the CAS have been published, and a lot of that is because either the parties don't agree. So you need to get that agreement on both sides, and sometimes it comes and more often it doesn't. And in relation to COVID, I think there's a distinction between events and I suppose dealing with arbitrations in the COVID time. And you're lucky that events are going on in your country. There's certainly nothing happening in Ireland, and only the elite athletes who are preparing for the Olympic Games are permitted to train. Everything else is shut down at the moment. But I have been conducting arbitrations online since pretty much since March for different institutions, be it for CAS or Sports Resolutions UK, for SDSI and for the ICC and other commercial arbitrations. So it's entirely doable to varying degrees of wonderfulness, shall we say, depending on the platform and where parties are coming in from and how much, how much you're relying on witness testimony. But it is doable but exhausting. So I hope that answers some of your questions.
Indeed, thank you.
Thank you, Susan. Nick?
Yeah, thanks. So COVID, first of all, I think there's been 3 important legal things that have come out. One is the sort of arguments you have about force majeure and those sort of legal arguments where contracts and so on in sport have been associated with event cancellations. Is a very important area. A lot of that has arisen internationally. The second is what you do about tournaments that are interrupted and how do you end them. There was a lot of work in England, at least, about the Premier League, which eventually managed to restart. But there was a lot of work leading up to that about what would happen if it didn't restart, who would get promoted, who would get relegated, who wouldn't. And one of the reasons it had to restart was because the amount of litigation there would have been had it not restarted would have been massive. You'd have had clubs in the Championship all saying they would have had a chance of being promoted, and so on. And then the third point on COVID, I just echo what Susan says. Since March, I've done all but one hearing remotely, including week-long trials with cross-examination of experts and so on. And I'm now so used to it. I'm not sure that there's much of an advantage of having an oral hearing, other than you get out of your room and you get to meet people and have a cup of coffee. But Susan's also right, it is more tiring because you're concentrating on the screen as well as papers. So that needs to be taken into account. On the agents, it's a very interesting and important question. I think a large part of me being able to establish myself as a football practitioner had come from establishing links with agents earlier on. I act for most of the agents in the UK and in fact in Europe now. And they are a very good source of work if you can get some work from the agents, because they will do everything for the football player. So the football player is never going to appoint a lawyer. The agent will appoint the lawyer for the player. And of course, the agent will do all the other negotiation for the player. And the agent, as Susan says, will often have their own work in terms of suing for their commission. And of course, they will be introducing people to clubs and owners of clubs all the time, and often introducing new buyers of football clubs to football clubs, which is a very big part of business for lawyers in sport in England in any event. So they are a good source to tap into. And then lastly, on the terms of split of work, I would say mine is probably about 50-50 on the record or not, but that is by and large because about half of my work is commercial disputes in sport subject to arbitration, which will not be published and will be private. And the other half is regulatory. And as Susan says, most of that regulatory stuff does get published, particularly if it's high profile. So it's often, as a sports practitioner, you often prefer to sometimes be doing the regulatory work, however it pays compared to the commercial work, because at least you get some good profile from it, which is important in this area as well.
Thank you, sir.
Thank you. Do we have further questions from the audience? Yes, please. Dr. Talhuni, who is also the steering committee member of the Arab and International Arbitrators Network.
Yes, thank you very much. That was very enlightening. I would say a session. Thank you for the speakers and the panel, wonderful panel. I have one question actually for the starters who's never been doing any sports arbitration. Where do you this question is for all the panel. Where do you think that is the easiest way or the easiest cases that an arbitrator should really shouldn't matter really the past experience, large experience than the very famous arbitrators. If you think is it not the football? Is it the tennis maybe, or is it any special sports that are easier to tackle? Thank you.
Diana, maybe I might
Please go
get
ahead.
the ball rolling on that. I think it depends on where you want to start. I certainly think that starting domestically is the best training ground, and trying to get involved with sports domestically. And if there isn't a centralized institution that is doing it, then trying to get onto the judicial panels of individual sports. I don't think I would be too choosy if I was starting out. It's whoever would, whoever has a judicial panel that you can get onto, or alternatively to try and establish a centralized body. But getting the experience, it's always the chicken and egg situation, isn't it? How do you get the experience if you don't have the experience? But certainly that's the advice that I give to my colleagues when they're asking me, or even getting on the board of a sports organization, so that you can see the internal workings and get a little bit of an understanding of how they work. And that is invaluable. You know, other people may come at it from an athlete point of view, and maybe they may do some representation for athletes and so on. But effectively, it's really getting any piece of work that you can. And by work, I also mean pro bono work. I don't mean paid work. And inevitably in sport, you're going to start pro bono. And that's the only way to get in, because it has become highly competitive. And also athletes really don't have any money for the most part, or small federations, so they can't actually afford to pay you. So that's where I would start with cutting one's teeth, and then develop from there and layer it on, and join sports law arbitration groups, and try and create that international network. And you never know, it's through those networks that appointments come and that experience is gained.
Thank you, Susan. Thank you.
Yeah, I would just echo that. No one sport is easier than another in terms of the disputes. The disputes are often the same in different sports. But I think often there are sports with perhaps less money and less structure. And they would be very, very happy, a lot of those sports, whether, you know, whichever country you're in. It's the same in England. They're often very happy to receive help, particularly if it's pro bono help, where they've got no money, whether it is, as Susan says, as a helping set up an arbitration system, helping them draft their rules, or whether it's representing pro bono athletes in hearings, which is very important service. Doing that, obviously, as lawyers, we all know if a case is too difficult or complicated or outside our competence, we don't take it on, unless, you know, no one else can, and the person won't have representation otherwise. But subject to that, I think those are the sort of opportunities you should look at to cut your teeth. And as soon as you have 2 or 3 experiences like that, that's then very helpful in being able to develop your practice and your network.
Thank you. Thank you, Nick.
Thank you very much. We do have 2 more questions as we're coming to the end of the webinar. I guess we just allocate one answer to those 2 questions. Mr. Taboub, I believe you had a question on the issue of breach of contract. You can unmute yourself and raise the question.
Hi everyone, thank you for the lovely session. I want to say, as Dr. Hussam also said, and greeted you all, good morning, good evening, and good afternoon for those who are just off their lunches. I come from an arbitration background in the commercial area, so Hussam was nice enough to invite me to this lovely session with you, ladies and gentlemen. To start off, basically, my interest would also coincide with some of the concerns in commercial arbitration as well. Going into 2021 with an extended view of COVID-20 as opposed to COVID-19, how would this reflect at the level of a breach of contract due to non-payment or delayed payment for transition or sale of players between the different associations or federations and clubs? And at the same time, how would this be looked at in view of calculating loss of profit when we are assessing a certain event or assessing a certain contract? You know, while flipping between how should I say it, force majeure or unconventional conditions as opposed to the usual norms of contracts. I'd love to have the views, and you're all more than capable to answer me, hopefully.
I saw Nick was nodding his head, so I believe that we can give the floor to Nick to answer the question.
Yeah, well, it obviously depends on the applicable law. In English law, force majeure is very difficult, and COVID would not give someone a valid excuse to stop paying a football player, for example. And that has not been possible in England. Not only is it not possible, it would be commercial suicide for the football clubs, because it would mean their assets, as players are to clubs, would be able to rely on the decision to walk out of the contracts as well. And so that's why the clubs won't take the point. There are force majeure clauses that have been introduced in contracts of lower league football clubs, which allow for the club to make deductions of salary linked to things like having no crowds and so on. There's then also FIFA law that applies in international transactions under the FIFA RSTP regulations, and those generally, again, are not is going to be very difficult for a club to get out of paying a player. But I understand from a case I took on for a player in Spain that the law is very different in Spain. So if the football contract is a Spanish football contract, even between an international player and a Spanish club, subject to Spanish law, it is apparently possible to deduct from the wages without negotiation. So the key here is establishing the governing law, I think.
Thank you very much. Do we have any further questions?
Diana, there is a question sent in writing from Mr. Hatton, I think, if I can read it. It's asking, what's the language used in sports arbitration and how does the plaintiff choose the arbitrator? Is sports arbitration is primary and appeal stages? So someone can answer this. Actually, I'm coming from a commercial background, commercial arbitration, and I have a question after that, of course, if the time still allows.
Deanne, I can tell you from a CAS perspective, the majority of the cases are dealt with in English or alternatively in French. Now, that's not to say that cases can't be dealt with in the local language by agreement of the parties, and obviously that would have an impact on the arbitrators that are appointed. Certainly on appeal, most cases are 3-person arbitrators, but they can be a sole arbitrator. So I think, you know, there's a flexibility in the system to allow for it by agreement, but the sort of the standard languages would be English and French, and obviously in any domestic arbitration court, it's going to be the national language or languages of that particular jurisdiction. So it's something that has to be discussed and agreed, but it's not an insurmountable issue. And where documentation or witnesses are coming in with a different language, then the obligation is on the party who is either bringing that evidence or bringing that witness to ensure that they also provide the translation. And I think we've already seen some of the difficulties with translation in that public WADA and Sunyang case. But these are things that really, you know, as an arbitrator, you absolutely don't want to trip over on something because of technology or because of language and translation. So it's actually a really important part of the process to get right and get it right at an early stage, I would say.
Thank you, Susan. So Dr. Hussam, for any conclusive remark or question, since we're running just a little bit behind schedule.
Okay, it can be actually a question with a concluding remark. Because we know from, you know, since the time when I started with the DIAC, I started DIAC in fact, and I know how arbitration or establishing arbitration practice in a certain country or in a certain even field requires full focus on spreading the let's say the concept of arbitration between different parties. And I'm referring to the arbitration agreement in particular. I mean, if you manage to convince all parties involved to include in their agreements a reference to arbitration rather than national courts, then you will start the first step towards arbitration, whether that is an ad hoc or then institutional. And of course, with that comes building up the procedures and having a list of qualified arbitrators of the top quality, if you can, in a certain practice. And of course, having the support with the national courts. Because if you have just only a national law and good practice without national courts to ratify, the result of arbitration, then you will not have a good practice in that jurisdiction. And I noticed that in sports arbitration, from the speakers and from what I managed to put together before this event, is that it is really strangely different from commercial arbitration with relation to that particular part. I mean, the agreement or having the consent of the parties. We try to shed light on that in various times, but I noticed that there is what is called mandatory arbitration, which is in commercial arbitration, it is completely abandoned, even forbidden, and considered as unethical, in fact, in some areas. But in sports arbitration, it is mandatory, like the governmental type of contracts where the government supersedes and imposes their conditions on whoever deals with them, and that is what happens in sports arbitration. Therefore, perhaps New York Convention does not apply because New York Convention requires the consent of the parties and the arbitration agreement to be in writing, and just a reference to any document that includes arbitration is sufficient to consider it as an agreement. Indeed, sports arbitration is totally different, and not totally in the sense of the procedures afterwards. I mean, the justice should always be perceived by the arbitrators and practitioners, but the first stages establishing arbitration and sports arbitration, including the consent of the parties and the sports law and the events and the speed and the confidentiality issue versus public procedures are all different. I noticed that, and I think that there is a lot more to learn in this area and a lot to exchange with international practitioners. And I hope to see the countries in Asia, whether that is the part in the Middle East. Okay. Thank you so much, Diana, for organizing that, and thank you for the speakers who enlightened us in this specialized area. And I would like to see Arab countries and Asian countries, and perhaps also in Africa, all work together with the European part and our also colleagues in the United States and other continents worldwide, working together in this area where all people from all backgrounds participate together in the sports events. So likewise, to see also arbitrators to do that and to work together towards one practice, hopefully in the future. Thank you, Diana.
Thank you very much, Dr. Hussam. We're coming to the closure. We've heard today very interesting and very relevant presentations on issues related to sports dispute resolution. The webinar has been very interactive, which I think is a testament that to the fact that there's interest of the audience towards this topic, and in fact we expect that the interest towards towards TIAC becoming the venue for a sport dispute resolution will also grow. We stand ready to be of any further assistance and answer any further questions that the audience may have. You all have our email addresses. So huge thanks to our distinguished speakers. The Ministry of Physical Sports and Culture of Uzbekistan. We did have also the representatives from the National Olympic Committee of Uzbekistan, as well as the federations, such as the Uzbekistan Athletics Federation. So thank you very much, and hope to see you soon again. Thank you.
Thank you.